Good afternoon, good morning, good evening, wherever you're joining us from. Thank you very much for joining our webinar this afternoon. And today, as you can see from the information I've put in the chat, we're welcoming Professor Sornarajah, who is an emeritus professor of law at the National University of Singapore. And Prof has been at various universities, and he got his PhD out of London and LLM from Yale. He's been head of school, he's fellow, he's been a research fellow at various international law centers and universities. And more importantly, for our purposes this afternoon, as you would all recollect, he's the author of the International Law on Foreign Investment. This is my own copy, which as I said to him, that I read it and I use it in my teaching. So it's really, really an honor to have Prof with us. And International Law on Foreign Investment is in its 5th edition now. The very first edition was published in 1994. So we may have people on the call who hadn't been born when the first edition was published, but it is great to see the book in its 5th edition. It's published by Cambridge University Press. Now, Prof doesn't only, he's not just an academic and a researcher, but he also sits as an international arbitrator for investment disputes. And that is really important for those of us who work in this field. So Prof and I met a few months back, and I said to him, he was speaking at McNair, their annual lecture on international law, and I said to him he had to honor us and come and share some thoughts with us. And so today, Prof is going to be engaging with the question whether African and Asian states should continue with investor-state dispute settlement, the ISDS system, as we currently know it. And so we're going to sort of engage with that and figure out whether some reforms, as we all know, reforms are happening, and what Prof thinks. This webinar is being recorded, so please, hopefully we have everybody's consent for that. I'm going to hand over to Prof. Prof is going to speak for about 40 minutes, and then we would have a question and answer, would open it up for discussion. If you do have a question that is burning, you can't wait, please type it into the chat, but we'll wait until Prof finishes his discussion, and then we would have a Q&A. Prof, over to you.
Thank you so much, Professor Onyema. It's such a pleasure to be with you at the School of Oriental and African Studies. Really, I used to spend most of my time at SOAS when I was doing my PhD, because the institute was just next door, and you got very good food in those days, Asian food and African food, at the restaurant of the SOAS. So I used to be there eternally, really, meeting friends and having a good time there. So I'm very fond of SOS, really. So let me begin with history, because Professor Onyema has already said that I began my interest in this course way back, really. I mean, I wrote the book in 1991, but my real interest started from the time I was an undergraduate, because that was the time when my home country, Sri Lanka, was nationalizing the tea estates and the distribution of petroleum in the country. So my interest goes back to 1956. So in a sense, I am a part of the history of foreign investment in independent Asia and independent Africa, where similar events were taking place. But I want to go even further back to the time when we were under the colonial domination of the European states. And at this stage, of course, we supplied slaves and indentured laborers to work cotton fields and sugar plantations in many parts of the newly colonized or planted world. So that was our history, a history of subjection and a history of domination. The uh, the countries of Asia and Africa were vast quarries from which natural resources were taken in order to furnish the industries of Europe. European growth has had much to do, or much had gained much advantage from the fact that there was exploitation of the resources of the peoples of Africa and Asia. Now, all that came to an end, a sudden end, when the process of decolonization took place. There was Gandhi sitting in front of trains, having his nonviolent movements in India, and of course, in other parts of the Asian and African world, there were bloody wars that were fought for independence. In Indonesia, the Indonesian independence movement was a violent one which fought a war against the Dutch, and so too in Kenya, Jomo Kenyatta fought a war against the British. But there was the period of decolonization, and we got freedom in the 1950s and the 1960s. So the period of decolonization was a period in which there was great hope amongst the people of Africa and Asia that not only would they have political freedom, but would also be able to manage their own resources. So, what happens in this period is that from 1950 onwards, the newly independent Afro-Asian states began to campaign for resolutions at the United Nations referred to as resolutions on permanent sovereignty over natural resources. This idea of permanent sovereignty over natural resources was very much an anti colonial idea because it was the resources of the African and Asian people that was being taken out of our countries in order to advance the economies of our European colonial masters. So, what Asia and Africa wanted to do was not only to get political independence, but also to secure the idea that every African and Asian country would be able to have control over their economies, principally the natural resources. Now, this movement, which started in the 1950s and the 1960s, became a larger movement and was enunciated in terms of what came to be known as the new international economic order, which took in not only investment but also trade. That 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 the structure of the world economy was inimical to the interests of the Africans and the Asians, and that there should be a restructuring of this order first by ensuring that control over natural resources passes to the African and Asian people, not to the states, remember, because if you look at these resolutions, they are carefully crafted to advantage not states, but the peoples of these countries. Because our freedom struggles were struggles of peoples, not of states. States had not obviously been formed, and therefore the struggle, the independence struggles, were struggles in order to assert the rights of peoples and not the rights of states. So every resolution that you see that was enacted by the United Nations, by African and Asian leaders during this time, people like Kenyatta and others, and Nehru and others, spearheading this movement, towards gaining economic control, you would find that they were articulated in terms of the sovereignty of peoples and not on the sovereignty of independent states. It's an important point to remember because what has happened in both Africa and Asia in modern times has been the capture of these states by politicians who are very pro Western and are keen on the development of these countries through a foreign investment process that is led by the West. So, this idea of a new international economic order that was formulated by the early leaders of our freedom movements, movements of peoples rather than of states, was geared to the notion that there should be a new structure in the world that was created that ensured just prices for commodities that were sent from natural resources that were sent from the uh, the third world to Europe, that that total sovereignty over natural resources should be vested in the people of the country. So these are ideas of reform that were instituted, and you would find, of course, that there was a great movement for nationalization of property. There was nationalization of oil that took place in many countries, Indonesia, Nigeria, and other places. There was nationalization of tea estates and other primary product related ventures. So there was a vast change, a sea change that took place in Africa and Asia. Now, suddenly all that halted. You see the first generation leaders dying off and moving out of the scene, the great surge that existed in the decolonization movement dying off progressively, and then you have also the collapse of the Soviet Union, which was a major event in the sense that the third world or the unity of the third world, which had sponsored the new international economic order, came to a virtual standstill. When you talk in terms of a third world, you always think in terms of the existence of two other worlds, the Soviet Union and the United States. So when the Soviet Union fell, there was no third world to speak of. And the third world itself was being led by new types of leaders who had new ideologies that had taken over their thinking. So we find a sort of a movement away from the ideals of the first generation of leaders, the idea that resources belong to the people, that the people must have control over how the resources should be utilized. Now, there also comes about what we called the triumph of neoliberalism in the post Soviet Union world. Here comes about a new hegemonic power. The hegemonic power is a single hegemonic power, the United States, controlling the politics of the world, so to speak. So there's a single monopolar international order that had come about that was led by a sole power, the United States. And of course, there was this famous book that was written at that time, the uh, the end of history, which trumpeted the idea that the ideologies of the United States had become triumphant over communism, and that the way to go for the future would be to ensure that markets were free, the economic philosophy of the United States, that there was democracy in the whole world, the political philosophy of the United States. So these twin ideas dominated the thinking of virtually all the leaders of the world, and they subscribed to these philosophies. China itself left its communism, announced its open door policy way back in 1969, and embraced this new philosophy with greater vigor after the Soviet Union fell, and so too India. So the two large uh, Asian powers, China and India, had totally given up the notions of the new international economic order, started practicing a free market ideology, making numerous investment treaties. You know that China has one of the largest number of investment treaties, some 145, and India followed suit with some 70 odd investment treaties made. So this period of 1990 is a period in which you find that there is a massive explosion of investment treaties that had taken place. From around 300 odd investment treaties in 1990, we have over 3,000 treaties made just in the period of the last decade of the 20th century. Massive explosion. In addition to that, you have a case decided in 1991, the Asian uh, Agricultural Products Limited versus Sri Lanka, in which the tribunal held that a dispute resolution provision that is appropriately worded, appearing in an investment treaty, could provide jurisdiction to an investment tribunal. So here is the idea that an investment treaty could give consent to arbitration in advance to a foreign investor who could invoke that provision unilaterally of his own accord before a tribunal. Normally, the tribunal of the World Bank, the ICSID tribunal. As you know, in 1965, the Convention on the Settlement of Investment Disputes had been made, and it had created this new arbitration center in 1965 that was dedicated to the settlement of investment disputes. It didn't have any cases until 1991. It had about 8 cases decided up till that time. So 1965 to 1991, this tribunal virtually had no business at all. But since then, again, you find an explosion of investment arbitration awards that come to be made. Now, not only has there been an increase in the number of these investment awards, but the law that is contained in the investment treaties has been expanded beyond the contemplation of the states that made it. You know, this is a new phenomenon because what happens then is that a new body of people dedicated to the interpretation of these investment treaties grows up, the arbitrators. So you have arbitrators, a group of people arising who settle investment disputes, and of course are geared to the idea that there should be settlement of investment disputes in accordance with what they see as the standard of investment protection. Now, these are people who transfer from commercial arbitration into this new subject, investment arbitration. So they take ideas from commercial arbitration into investment arbitration. Now, of course, in commercial arbitration, you know that one of the basic ideas is that a contract is sacrosanct, that if a contract is broken, damages must be paid. So these ideas are taken without criticism, without any notion that there is a public law entity that is involved, the state, into the body of investment arbitration. What more, of course, this body of arbitrators are people who draw an advantage from investment arbitration. They can make it a very lucrative business. So you would find, say, for example, I don't want to mention names, but you would find that arbitrators and, of course, Professor Onyema would be knowing all of them because very fortunately, very fortunately, I say this, many of these people are women, right? Very, very, very interesting because in public international law, there has been such a discrimination against women. You know, you don't find women featuring in public international law in early times until perhaps the coming of this century. You have had no judges of any significance sitting on the International Court of Justice. But here, when it comes to investment arbitration, the front runners in arbitration are ladies, right? The women who have sat in over about 300 odd arbitrations. Many of them are, of course, people who have taught academic courses at universities on this subject. So that's another phenomenon. Now you would find that many of these arbitrators are professors. So you don't know how they become professors, but you would find that they would carry the title professor behind them, like Professor Onyema and I do in a sense. We sort of sit and work and we write things, but these people somehow become professors of universities, giving them a lot of credibility. Now, so this group of people have an interest in developing the the this dedicated area of investment arbitration. I wouldn't want to tell you how much an investment arbitrator earns. He earns a huge amount of money, right? So the standard fees of an arbitrator in ICSID is about $3,000 a day, right? So if he sits for 10 days, he gets $30,000. And of course, he's paid for writing an opinion, for reading the material in connection with the arbitration. So the amount of payment is huge. Arbitrator would, on a particular case, earn anything from 100,000 to $200,000. So that being the case, then I put this idea across that arbitrators have a great interest in ensuring the expansion of the law in this particular area. So if you have a innocent looking phrase like fair and equitable treatment in the provision of the treaty, then it is given a hugely expanded interpretation, meaning that any legitimate expectation that a foreign investor has should not be broken, and if it is broken, then damages should follow. Now, the Americans and the Canadians have, in third party intervention, stated that they never intended this to be the meaning of this phrase, fair and equitable treatment. Nevertheless, arbitrators have continued to go on giving expansive interpretations of this very innocent looking provision, fair and equitable treatment, so that we know now that its meaning has gone well beyond what was intended by the parties. I give you that as just one example. There has been similar interpretations placed by arbitrators on provisions of investment treaties that go well beyond the intention of the parties that had made these treaties. Excuse me. Now, in addition to that, then you also have a class of lawyers developing, right? So this means that the major law firms of the world, right? And again, I mean, you can look it up yourself. If you look at the exit cases, you would find the largest law firms of the world, Freshfields of England, White and Case of the United States, all of them have dedicated sections devoted to investment arbitration, right? And you can then look at an award and find out how much the these firms earn. They earn well into about $1 million per case, because the cost of the arbitration is granted to the winning party, and in the course of granting costs, the arbitrator would disclose the amounts that are paid to law firms, and the amount is substantial. So this would mean that every developing country, and most of the cases are brought against developing countries like Bangladesh or Pakistan or Ghana or Tanzania, would have to cough up a large sum of money to lawyers as well as to arbitrators in defending cases that are brought against them. Now, the notion of an investment treaty is that massive development comes into the country through foreign investments when you sign a treaty. There is nothing to show that this happens. I mean, we have had these treaties for 80 odd years now. The practice of making these treaties started in 1959, and we have had experience of 7 decades of these treaties. And there's no way in which you can show that these investment treaties has led to development in Africa and Asia. Rather, they have guaranteed the rights of foreign investors who go into work in areas of mineral exploitation or of the building of large projects. There's considerable, there's considerable recent research done by economists to see whether these investment treaties do lead to large flows of foreign investments. Many of these studies come up with a negative result. There's no way that you can prove that there is a flow of investment treaties taking place in Nigeria because Nigeria has signed investment treaties. Rather, people go into Nigeria because Nigeria has vast amounts of oil and other natural resources, and a capable, uh, skilled labor that could be used to work in these areas. So there is a sort of a legitimacy crisis that has developed in this area. We have virtually sort of thrown out our early leaders like Nyerere, who has written a lot on neo-colonialism and other matters, of Kenyatta, Nehru, and Sukarno. You know, the people who led the movement towards permanent sovereignty over natural resources and invited a new type of colonialism, because once colonialism through military force failed, what has emerged is a colonialism through the instrumentality of the law. The result that has taken place is that these bilateral investment treaties project the notion that the states of Africa and Asia must conform to certain standards which are by drawn up in the treaties, of course, to which we consent, but not only to these treaties, but also to the way these treaties are interpreted by arbitrators to whom we did not consent. I mean, what gives this select arbitrators, people who hold their wine glasses in a precise way that Englishmen are taught to do at Cambridge or Oxford? What gives them this idea that they should set standards for the peoples of Africa and Asia? That's a question that you should ask. Now, given this resulting situation, and I also must say that the damages that are awarded against states are huge. They're not just for damages as for a breach of contract, but damages that are so extensive as to take into account the future possibility of the earnings that could have resulted from a particular venture. So, take for example a case like Tethian versus Pakistan. An Australian company comes into Pakistan to prospect for gold, and they don't find much gold. But because of the area being an area of insurgency, and because the local administration had not given permission for this particular project, the government of Pakistan rescinds the contract. The company sues and is awarded damages of $50 billion. $50 billion. I'm sorry. I'm exaggerating. 50 billion was the Russian award. $6 billion, right? I mean, in a Nigerian case again, a $6 billion damage was awarded. Now that's a huge amount for a developing country that faces many economic problems, right? Having award of $6 billion made against it by arbitrators. So it's in this context that you have to view these investment treaties. Should you make these investment treaties? And I see that there is a new book by a Ghanaian author called Doug Benja, who agrees with me and says that these treaties should not be made, right? I think if you have an interest, you should read this because it is written by a young African author who has extensively studied this question as to whether investment treaties do in fact uh, promote development in African states. That there are many attempts to reform the system that has come about. Now, these reforms, Professor Onyema would not agree with me perhaps, these reforms are not credible reforms. I mean, there is a current process that's going on before UNCITRAL, which seeks to bring about a reform of investment treaties. Why reform a system that is not at all profitable from the point of view of the developing countries and does not promote economic development? Right? I mean, when you look at an investment treaty, it is structured on two falsehoods. The first falsehood is that it seeks to promote a reciprocal flow of foreign investment, which doesn't take place, right? I mean, when you say that there's a treaty between the United States and Bangladesh promoting a reciprocal flow of foreign investment, there's no way that you can show that Bangladesh makes investments in the United States of any significance. It's only a one-way flow that takes place. The second untruth is that investment flows promote economic development. Again, as I have already said, that is untrue. So the treaties are based on falsehoods. And why promote a system that is based on falsehoods? Treaties are continuing to be made. And they're being made, for example, by India, which is supposed to be now a country that is seeing fabulous growth. Despite it, the Indians terminated their treaty, but still brought up a new model treaty in the hope that it would assuage the feelings of foreign investors. And sorry, and that they would still have the confidence of bringing investments into India. So India now has a new model treaty, which it calls a balanced treaty. So that is a way of reform now that many states are engaging in, including African states. What happens is that you have investment protection stated, but you have defenses as well. Defenses like uh, the laws that protect protect the environment, laws that protect human rights, the laws that ensure that climate change does not take place, the laws on national security. Now, why do you have defenses of this sort? I mean, this is the function of a state to ensure that there is no environmental damage, that human rights are protected. What is a state there for? Why is an African state making a treaty saying that it is a defense, that it is protecting the human rights of its people? Isn't it its duty to do so? Why is it so defensible that it should go and make a treaty saying it is a defense to liability, that we are protecting human rights? So that's what the Indians do. We are protecting human rights, so therefore it is a defense. I mean, that's a subversion of the essential principle that the safety of a people is the supreme law, of any state. Why should it be stated as a defense, as these new investment treaties do? So what and the reforms that UNCITRAL tries, they're all related to procedure, not to substantive law. There's no effort to change the fair and equitable treatment. They try to sort of define who should not sit on arbitrations. They try to say that arbitrator should not have been a practicing lawyer before, or that he should not have certain stated biases. So these are reforms based on procedure. The traditional way in which developed country lawyers have taken steam off the pressure that third world lawyers build up. When you say that you are dissatisfied, you build up enough pressure for reform, they sidetrack you neatly by saying, let us reform the procedure and things will be okay. So that's what's happening with the ancestral ways of reform. And I think, I mean, coming back to my favorite friend, Dak Benja, whom I've never met but whose book I greatly admire, I would agree with his view that in Africa in particular, and he is, of course, speaking of Africa, the constitutions of Africa is stated in such a way that they are rejective of the notion of investment protection through treaties. If the regulatory power of the state is to be preserved fully, then you cannot make treaties. The constitutions require the protection of the state to ensure that public interests are promoted. If you have to protect your people against environmental degradation, you have to protect them from human rights violations, protect indigenous communities, then how can you make these investment treaties? And that's a credible argument that has to be considered. So now I finished my 40 minutes as I said I would. And let me ask you questions, but let me also make one further point, if I may. The earlier, the earlier, the earlier history that I had adverted to was the history of exploitation by the Europeans. But there is, in present times, a great change that is taking place. The change simply is that Europe and the United States, the classic exporters of foreign investment, are now becoming massive importers of foreign investment, right? So they are going to face a lot of investment arbitrations in the future. At the same time, you would also notice that the countries of Asia, at least some of them, like China, like India, are massive exporters of capital, right? I mean, you would find, for example, India, the largest car maker or the most prestigious car maker in the United Kingdom is Jaguar. But Tatas of India owns Jaguar. Tatas of India owns the largest steel mills in England. Tatas of India owns prestigious hotels in England. So one of the largest investors in foreign investors in England would be Indian companies. So to China. China is taking over as a large investor in many African countries. So it is possible that the future exploiters of the world are going to be those who had been in the third world and been one of us in the past. So one has to sort of fear this problem too, that those who were in the front ranks of the champions of the third world are now in the front ranks of the exporters of capital. And they are also making investment treaties. Are they of any less strength than the investment treaties that the British and the Americans and the French made? No, no way. The Chinese investment treaties are very strong. Indian investment treaties are not as strong, but they also want to make investment treaties, not give them up simply because of the fact that they have foreign investors. Some of the largest investors in the world are Indian investors, like Hindustan Heavy Industries, Hindustan Electricals, making many products that are sold all over the world. So, in that context, then, you would find that even smaller Asian countries like Singapore and Malaysia export capital and want investment treaties to be made. So, when I and people like Dagbenja say, we must do away with investment treaties, whether that's going to be real or not is a matter for conjecture at the moment. Thank you so very much for listening to me.
Thank you so very, very much, Prof. I didn't expect anything less. So thank you. Your views are very well known, and Dominic Dagbanja's views are also very well known, and he looks at it from a constitutional law perspective. And I've put a link to his book in the chat. So it's open for Q&A where people, if you want to ask a question, if you want to make a very short comment, please raise your hand. But Prof, before I start seeing hands, I think where the note on which you ended, we're seeing that quite a number of jurisdictions are both capital importing and exporting. And one of the concerns and constraints that I see in the Africa Continental Free Trade Area, the investment protocol, is the fact that if I was advising a party that is African, it would be very difficult for me to say to them to just hold on to what they have within the investment protocol because they have less protection. I think that's part of the problems we're seeing because traditionally capital importing are also becoming capital exporting with a free flow of capital. And so states are constrained in wanting to hopefully protect their citizens and their own investors outward going, while at the same time wanting to protect themselves, if you like. And I think that is a major tension that most states have not found a proper way to deal with that. I don't know if you have any views on that, and then we'll take some questions.
Yeah, one thing that always puzzles me is why we make an argument of that sort. Uh, when you go to France, Do you worry very much about whether there's an investment treaty that protects you or not? You just invest, or in the United States, or in the United States. We don't sort of ask whether there is an investment treaty in the United States before we invest there. The most corrupt Supreme Court in the world is the Supreme Court of the United States, right? Because all the judges are appointed by Trump. So why is this great hesitancy of saying our laws are not good enough? I mean, the presumption of the investment treaty is that you make it with a developing country on the assumption that the laws of these developing countries are not good enough. And why that assumption? And why should you make that assumption critical, run down your own country by making these investment treaties, and give control over what is done by your country to three men of uncertain competence? I mean, if our judges in Nigeria or in India are not competent, what is there to say that these three men, who may not have practiced any law, in sitting in Geneva or in London or in Washington, are any more competent to deal with our problems, which arise from within our country? I mean, that's a paradox that you have to address, when you say my foreign investor is worried about the law that would happen here. Why is he coming to my country? I mean, he comes because there are things to be exploited in my country, cheaper labor, more resources that could be taken out. So
I agree with. I think I agree, Prof. But the concerns that I have is
yeah,
one of that we don't continue to maybe I should use the word run around patrimony and
yeah,
allow we keep blaming the other. So I can understand the argument and the way you have framed it up until maybe 2000s thereabouts. I think we can, now that we have greater information and we have many investment treaty disputes, and we can see how arbitrators of questionable pedigree, if that's what the way you want to put it, those are not my words. If we're concerned, because we can see the expansive interpretations that we're getting. And then, of course, I fully agree with you that part of the concerns is that we have a cadre of practitioners whose practices are built on investment disputes, not just as arbitrators, but as counsel. And the only pushback is that arbitrators don't make as much money. And I think for lots of arbitrators, $100,000 is not much, but they don't make that much. It is counsel that makes all the money. But because we have some people who act as investment treaty counsel, they do a lot of counsel work on the call, I shall be kind and not harass them too much. But I fully appreciate and I fully agree with the concerns you have raised around developing countries. But the question I have for you before I see hands is, why do developing countries continue to sign up to promises that they know they cannot keep? Why are they continuing to engage in this whole system and
yeah,
sign BITs?
yeah. That is a puzzle. That's a puzzle that I would answer in the following manner. One, of course, there is pressure that is brought. So this pressure, of course, would become significant when there's an economic crisis in a developing country. Like, say, for example, in the case of Indonesia, we had a crisis prior to 2000, right at the turn of this century. And the IMF clearly required Indonesia to sign investment treaties as a condition for giving aid. So that may be one reason that the World Bank, the IMF, and other aid-giving countries require investment treaties to be signed as a condition for trade. Then, of course, there's the phenomenon of investment insurance. Again, investment insurance is not provided by states, which have agencies for insurance, as well as private insurance companies, if the country to which the business investor goes has no investment treaty. So again, there is a sort of a inbuilt pressure to sign investment treaties. Third is that if one country signs an investment treaty, and particularly if it's a small country like Tanzania or Ghana, or in Asia, in the case of a smaller country like smaller economy like the Thailand, or if say Singapore signs these treaties, there's the fear that Singapore will attract more investments than Thailand. So Thailand also goes and runs around signing investment treaties. So there's a pressure, peer group pressure that builds up amongst groups of countries, African countries or Asian countries, to follow a particular leader, right, who receives large investments. So Singapore is one such country in Southeast Asia, small country but having so much of investments. So it signs treaties, others would follow. It changes its approach, then others would change. So there is this image problem, that you should sign these investment treaties. So, so there are a lot of inbuilt pressures that conduce to the making of investment treaties, and that's why I say that Dagbenja and I and others may shout mightily, but the chances are that these investment treaties are there to stay for some time. Yeah.
Thank you so very much, Prof. I want to call upon Mr. Hussein Hari Casey, who's a professor of practice here. Before Hussein comes on to conclude the discussion and to thank Prof. Another professor of practice with us, who's going to become a Casey soon. I think he's pursuing Hussein, which is Beju Vasani. Beju Vasani, Hussein, and myself, we teach the international investment law course here at SOAS. Beju, please.
Thank you, and Professor, thank you for those remarks. Um, I wanted to ask the following question, which is, in light of, and you've argued very persuasively for many years in relation to, let's say, structural imbalance or the biases within the system, and you say the system is here to stay, and so that's sort of a something we have to accept. Is reform possible to uh, to change that structural imbalance, or is the most intellectual honest position to do like the EU is doing and abandon the system altogether?
Well, I think my argument always would favor the latter situation, because the problem simply is that, as I was suggesting, there is an inbuilt core of arbitrators who cannot easily be displaced, and this core of arbitrators would take any investment treaty that is made with whatever reforms and take it back to the days of pristine investment protection. You see that in cases like Eco versus Colombia, where there is a new style arbitration treaty that has environmental protection as a defense. But the way that the defense is treated is as if it doesn't exist at all. So that's a sort of a tendency that exists. Halfway reforms like balance treaties are not going to work simply because of the fact that entrenched features of the existing system, which cannot easily be changed, will militate against reforms that are attempted. Thank you.
Thank you,
Thank you.
Professor.
Thank you very much, Beji. It's lovely to hear your voice. I now hand over to Professor Hussein Harikesi. Hussein, please.
Well, thank you very much, Professor Sornarajah, for a tour de force, as we all would have expected from you on this issue. And I think we're grateful for you expressing your views on this. Obviously, your text on international law and foreign investment is one that many of us refer to quite a lot. We might use it more when we're defending states than acting for investors. I think it's fair to say. But certainly, you've been very much making these sorts of points for a long time, long before many others have come to make these kinds of arguments. So I think in many ways you were well ahead, if you like, of these kinds of points. You made some interesting remarks I'd just like to briefly touch on. I mean, you talked about the text, The End of History, and I think when we look at the world around us, we're reminded of Mark Twain's comment that history doesn't repeat itself, but it often rhymes. And we do feel ourselves very much in the midst of history. Perhaps some might say there's not enough law going around, query whether that has any relevance in the context of international investment protection or not. I mean, it seems to me that your critique is a very fundamental one, in that it's not just of the arbitrators or the scopes of protection standards, although I think you make important points in both of those respects. But I think it is more fundamental, and it goes to what you referred to as colonialism through the instrumentality of the law. And I think your position is that there shouldn't really be another layer on top of national laws when it comes to investments. And that, I think, is consistent with you saying that India and China have big outbound investors and, kind of situations where they are now increasingly bringing the claims. And that is no less problematic. So I think if I've understood it, it is a very fundamental critique of having an additional layer beyond the national legal layer for international investors. And I think you've set that case out, very, very clearly. So I hope that summarizes the position that you've taken, but we're very grateful and honored indeed to have had you give us this presentation today. So thank you very, very much indeed.
Thank you, Hussein. Thank you.
Prof, thank you so very much. We had 3 of our professors of practice were on the call, and one has had to go for a meeting. So that shows the high regards to which our center holds you and your work, which continues to guide us, as my colleagues have mentioned. So to everybody who's attended, thank you so very, very much. And this brings our webinar for today to a close. Thank you very much, Prof.
Thank you.
Bye,
Bye-bye.
everybody.
Bye-bye.
Thank you.